I'll hand it very quickly over to another person I have the pleasure of working with, who's been a real supporter and leader of this work at the Faculty of Law, Professor Peter Szigeti.
Hello, and I'm only here to welcome Professor Grimmelmann, and I'm thrilled that he's been able to join us. Professor Grimmelmann is the Tesler family professor of sorry, just checking. Tesler family professor of digital and information law at Cornell Law School and Cornell Tech. He's has been a real inspiration. His work has been a real inspiration to me, and I think to many others who are interested in law and technology. He has written on basically every aspect of law and technology, from search engines law through copyright, through international jurisdiction, through legal theory about the challenges that certain aspects of law and technology mean for property law. For example, he is the author of a casebook on internet law, and currently working on a book on AI's ability to interpret law itself. The working title, if I'm not mistaken, is CPU Esquire. He has written altogether over 50 articles. He's a contributor to Wired, to Salon, to the New York Times. So I'm basically, with that, I would just like to welcome him and call everybody's attention to the undoubtedly great keynote speech that we're about to hear.
Thank you, Peter, for that very kind introduction. And thank you especially to Hero and the others organizing this event. I'm really grateful to be here today and to get a chance to talk to you all about copyright and AI. And this is a subject that I've written a bit about, thinking about how copyright treats authors and how it treats readers in an age when computers and AI technology are increasingly part of the process of how we write and how we read. But the advances in machine learning and AI over the last few years have been so stunning that it's hard to keep up with them. They invited a lot of speculation about whether we need to fundamentally rethink how copyright works for an age of AI creation. And I think my answer is no, that we don't need to fundamentally rethink copyright. Its abstractions and its concepts and its doctrines work quite well, actually. If we may need to rethink anything, it will be about who we are and what we mean when we say that something is artificially intelligent. So I want to talk a bit about how copyright thinks about people. And then I'll dive into copyright doctrine on authorship and infringement when computers and AIs are involved. And then I want to close again by thinking a bit about how copyright thinks about people and how it might incorporate thinking about computers into that story. So my starting point is going to be in American copyright law and theory, with some ideas that we get, in particular, from Justice Holmes, that in a case called Bleistein, involving infringement in circus posters, he was confronted with the idea that these posters advertising a circus were not a proper subject of copyright because they were low art, because they were advertising, because they were of low quality, nothing great about them. And he responded in language that really nails how the American copyright system, and really the copyright tradition that we associate with the common law world, thinks about creation. He said, the copy is the personal reaction of an individual upon nature. And I should say, by copy there, he means the original, the work created by an author. Personality always contains something unique. It expresses its singularity even in handwriting, and a very modest grade of art has in it something irreducible, which is one man's alone. That something he may copyright. And the idea there is that copyright, so we call this a romantic conception of copyright, that the individual creator has something ineffably inexpressible that makes them a unique person. But when they express it, paradoxically, that expression is a part of them, and it's their reaction upon the world that is uniquely tied to their authorship. And this idea runs all through copyright theory, and it's just there are a wonderful series of work done unpacking the idea to which that is central to how copyright works. And the same, I think, is true about how copyright deals with the audience. So that when we compare two works and ask if they're similar, we ask if the audience, the reader, would regard them as the same. To quote Judge Learned Hand, one work infringes on another if the ordinary observer, unless he set out to detect the disparities, would be disposed to overlook them and regard their aesthetic appeal as the same. That is, does the reader see the originality in the defendant's work as coming from the plaintiff? Have they borrowed that personal reaction of the individual upon nature that the plaintiff put into their work? And if so, they have infringed, and if not, they have not. So who is an infringer in this picture? An infringer is somebody who coasts on the creativity of others, who does not provide creativity of their own, who is merely mechanically reproducing it to make more copies to sell to the public. They are profiting by borrowing somebody else's personality. And in this schema, a creator who actually appropriates some other work and goes beyond it is going to be protected. So while a slavish copyist, to quote another case, will infringe, somebody who engages in what the American courts call a transformative fair use will not infringe. Somebody who enriches the work with new information, new aesthetics, new insights and understandings. And this is to quote Judge Pierre Laval, this is the very type of activity that the fair use doctrine intends to protect for the enrichment of society. In other words, when the potential infringer becomes an author themselves, then they are protected. And then their work is itself creative, copyrightable, and non-infringing. So the idea here is that you have a romantic author who creates using their ineffable personality, and we have readers who encounter that personality, and we encounter it as people. We experience our own humanity to the encounter with a work. We perceive the author's humanity, and it's that transmission that copyright aims to protect. So let's talk about the degree to which computers challenge this story. And I'm going to go through 5 ways in which computer-based works might disrupt this story. And I'm going to argue that none of them really fundamentally change it. So the first and most obvious is that a work that is digital exists in a digital copy. Instead of being print on a page or paint on a canvas, it exists as a pattern of ones and zeros in some storage medium. It could be a solid-state drive. It could be a magnetic tape or a floppy drive, if you remember older technologies. But the idea is that it's just ones and zeros, and that the information is no longer subject to creativity. We've lost something in the way people complain that CDs don't have the richness of vinyl. When you digitize it, you lose something essential. Well, I don't think any of us here really believe that. I don't think that we can't have a deep aesthetic experience listening to music from a streaming service, or that you can't have a truly personal experience watching an author read a poem in a recorded video. The essence of what copyright protects is present in these copies still. They are still material objects from which the work can be perceived. And the truth is, for any category of work that the Copyright Act means to protect, you can digitize it in some way. Even a sculpture can be digitized. Take a laser scanner, scan it with high precision, record its exact shape, and you can 3D print new models of the same object. So any copyrightable work can potentially be put in a digital copy. And while it may not be identically the same experience, for many kinds of live theatrical entertainment, you truly have to be there. For most cases, many of the things that make the work worth protecting, that audiences care about, are present even when the copy is digital. So the second thought might be, well, something is different when a work is born digital. It's one thing to film actors and then put that movie on a streaming service in ones and zeros. But it's something else when the work itself started out on a computer. Maybe when poets type rather than write, something is different. But again, I think you can see that creativity today exists in all of these other forms. For every kind of copyrightable work, you can find a way of working digitally from the beginning. Composers who put their music into notation software rather than writing them out longhand produce the same scores at the end. There are so many artists who create digitally. They post YouTube videos of themselves drawing out these beautiful sketches. Musicians work digitally from the beginning when they're in GarageBand. Even architects and sculptors use digital creation tools. And the fact is, there's no essential difference between analog and digital creation. Any process you can imagine could be digitized if you followed it along closely enough. Just record every brushstroke as it happens as ones and zeros, and there's no essential difference to the creativity itself. So I think using digital tools doesn't by itself fundamentally change the character of a work. A third difference we could consider is the use of algorithms to create. That rather than individually placing every detail, we create algorithms that introduce some variation. And I have to say, this has never struck me as terribly strong as an objection, because we've always had artists who create algorithmically. Jackson Pollock created a bit algorithmically by flinging paint on a canvas. Printmakers create algorithmically when they run off editions of hundreds of the same print. And people have always incorporated elements of procedural creation into their works. And when a person uses a Photoshop filter to insert a background texture, that's a kind of algorithmic creation too. I don't think we regard the final picture as somehow lacking essential creative elements. It still expresses something about the artist's vision that is reflected in the work that the audience sees and reacts to. The fact that an artist might choose to employ algorithms as part of the creative process can help them realize an artistic vision rather than preventing one from arising in the first place. So the fourth difference is the one where I think we really start to see genuine and meaningful challenges to the way in which authorship exists in work. And I call this sequential creation. And this is what people start to think about when they think about, did the AI create this work or did some particular person? So imagine more than one creator creating a work. And there's the sense that if you created an AI and I push the button that sets the AI in motion, did either of us really create it, or did the computer itself make this work? Well, I think these problems are hard. They are really difficult authorship problems. But they are not problems that we resolve today by declaring the computer to be the author of the work. Microsoft Word is not the author of anything that I write using it. Microsoft is not the author of any of that either. The creativity, the things that you recognize as coming from my personality, those all came from me. Microsoft Word is just a tool made by Microsoft for use of authors. Now, there are cases in which the user is not meaningfully the author. You can regard a film clip as a kind of program. It's a file on a computer, and when you click on that file, you launch a program, and that program then proceeds to display something on the screen. And let me be honest, I am not the author of an Avengers movie when I click play on it. There's a movie studio with lots of creators whose visions are reflected in it. Those creators are the authors of it. I'm just a person pushing a button. What I want to submit to you is that most so-called AI creativity sits on a spectrum between those two. We are really looking at the relative contributions of the creator of the program and the user. And there are lots of other kinds of stories. So I could take your creation, I can put it in part of mine, and the resulting work reflects both of ours. We could work together. Copyright has a lot of categories for this. There are infringing copies, there are derivative works, there are joint works, there are sole-authored works, there are even uncopyrightable works where you create something and then I so completely efface it that nothing remains. But the point is, this is an existing set of categories. And trying to create a blanket rule that the AI created the work is a way of avoiding the question. Rather than asking who contributed what creativity to this work, which is what copyright theory requires, asking for the AI to be considered the author is a way of trying to resolve all the questions at once by fiat. And you can't do that while remaining true to copyright's own conception of what it is and what matters. If you just blanket declare AIs to be the authors of the works they emit, all you have done is avoid the question of where the creativity in the work that people perceive comes from. So the final, and now most conceptually difficult example, would be procedurally generated works, ones that are non-deterministic or random. These are the cases in which the person who sets the process in motion doesn't fully know what will emerge. And the temptation is to say, because the author, the person pushing this button, setting it in motion, doesn't know what will come out, they are not the author of what results. If there's an author here, it must be the process itself, and therefore the process itself must be the creator. And that has a certain plausibility when it comes to something like running GPT-3 to emit a short story. If I start it with a prompt, like, one fine day there were 3 little bears, and then I ask it to complete for me, it will produce something. I don't know what it'll produce. It's very tempting to say that mysterious process is the author of what results. Except that if you want to find a mysterious process that results in something I didn't fully predict or control, then we wind up in a world of great confusion as to centuries of existing copyright practice. Take, for example, Jackson Pollock flinging paint at the canvas. He's not fully in control of that. Do you want to say that gravity is the author of the work? Yes, there is a sense in which atmospheric forces and the particular consistency of paint and other factors that were not predictable by any human, including him, result in the form of the work takes. But this is not to say that those things have what we would recognize as authorship. They are no more authors than the ocean is the author of the shape of the waves that crash on the shore or the erosion patterns in rocks. Authorship is a category we attribute to things in copyright policy. It's something we as humans decide to say is present to recognize something as a creative work. And using that logic, if we want to attribute authorship in that picture of Jackson Pollock plus paint plus gravity, we attribute authorship to Jackson Pollock because he is capable of playing that role, because it makes perfect sense. because there is no other claimant on stage who we could attribute authorship to. So in that setting, trying to say that the AI in the middle is the author doesn't really work because it can't play the social roles we expect of an author. This is an idea advanced by the late Ian Kerr and by Karis Craig in a really smart paper called The Death of the AI Author that I'm going to be returning to a couple of times. But my argument is going to be that the Jackson Pollock is a perfectly good pragmatic solution that is consistent with how copyright thinks about the world, that offends no great policies, and that basically works for the concepts we have to play with. We don't need to introduce AIs as authors yet for the system that we have in the world. There are certainly some hard cases involving machine learning-based AIs. You can set them loose to create any kind of fiction. There's AI Dungeon, which is something that plays an interactive narrative text video game for you, where it fills in the world based upon GPT-3's model of the world. There are amazing style transfer APIs that will create a portrait of you in the style of a generic 19th century portrait, or that will render music in the style of musicians that never existed. These are all highly creative. In the case where one person or one team creates this AI and then runs it to create things, no harm is done by treating that team as the author of the resulting works. They created tools and used those tools to create. That's perfectly reasonable within a copyright system. If they make those tools and I just push the button to run it, they're still the author. If they make those tools and I contribute prompts and create things, that's a hard case in terms of copyright's questions of where the creativity came from. But it's one we can resolve in practice, pragmatically, because it's all dealt with by licensing. Most of these licensed AIs, they'll turn them over to the public, either on terms where they license them strictly and tell the people who use them what they can and can't use them for. So this should have been the case with a piece of movie-making software called Mova Contour, which was, the creators of that software, in a licensing dispute, sued Disney and others for using it and claimed they owned the movies that were created with it. It's a copyright dispute of derivative works. It's ordinary system can handle that. And the other extreme, when these AI companies put out public models for anyone to play with, they're effectively saying, we don't claim authorship in what results from using this. You, the user, should just go ahead and claim to be the author of anything you produce. You're providing the prompts. You are steering the direction of this. In essence, you are like the user of Microsoft Word creating a story by writing in our tool. Our tool helps you out more. It helps you out even more than Photoshop does, but it's still a process under your control. You can control the outputs enough that no harm is done treating you as the author. So to wrap up this part of it, the authorship part of the talk, I think that copyright's existing concepts and doctrines work well enough, at least for now, for cases where computers or AIs are involved, without needing to introduce the idea that an AI could be the author for purposes of the Copyright Act. And they work because the conceptual architecture of authorship fits the people in the system well enough that we don't need to treat the AI as a person too. And pragmatically, in terms of what actually happens and who gets to control copyright and assert ownership of the work and license it or sue on it, the solutions pragmatically are good enough, even if they're not always perfectly conceptually pure. So that basically the AI drops out of the system. We don't need to pay attention to it. It's not a person. Okay, so let's now switch over to the infringement side. The question of, can a computer infringe on a copyright? Life here is interestingly different. So I want to start with that idea that a person consumes a work by engaging with it, by seeing it, by experiencing it, seeing, listening. That's how we as humans respond to copyrighted work in a way that triggers copyright. Now, the reader is not typically an infringer. They are a person the work exists for the benefit of. Copyright's infringement architecture sues the people who provide unauthorized copies to listeners or readers, or occasionally to people who steal for themselves infringing copies. But for the most part, it focuses on those who market the audience of readers. But the really important point is that there is an audience, and that audience is the one whose attention copyright cares about. Well, it turns out that there are cases of possible infringement where there is no audience, and that changes everything. So I'm going to borrow a concept from Matthew Sagg, who calls it non-expressive reading. And I want to trace the story of how non-expressive reading becomes more and more important in US copyright law over time. So I'll start with a case called Sega versus Accolade from the 1990s. And Sega is the video game publisher. Its library is now owned by Nintendo, but back when it sold its own consoles, it had one called the Sega Genesis, and it tried to take a licensing fee from every work that ran on the Genesis. Accolade wanted to make Genesis games without paying the licensing fee, so they took some Sega's games and reverse engineered them to understand how they work. Now, reverse engineering necessarily requires copying. You can't look into table at the code without reading the code and providing it to mechanical tools that tell you about how it runs and how it works. You're looking to see which instructions jump, where the art assets are stored, and so on. Now, if you want to do this on a transformative fair use test, you could do this by saying, oh, they created their own game, so therefore that makes them creators. But I don't think that the audience, I am also a creator, so I should be able to copy all of your work without permission, really flies. We don't let novelists burgle the contents of entire bookstores. We don't let musicians just copy the entire catalog of record companies. There is some sense that you should pay for what you use. And the other transformative fair use argument that's trickier is that the actual copying Accolade is making is intermediate. They're just looking at the Sega code on their way to making their own work. So there's a lot of literal non-transformative copying happening on the way to something which is so transformative, it's not even substantially similar to the work it comes from. So what the court does is it doesn't even rely on fair use. It says the games don't need fair use, and the intermediate copying is protected by fair use. Sorry, I misspoke there. The ultimate games themselves didn't need fair use. The intermediate copying for reverse engineering is protected by it. It's the only way to gain access to the ideas and functional elements embodied in a copyrighted computer program. So if you think about this from the perspective of who is an author, who is doing the work that copyright loves, Accolade was an author. They were protected by copyright, and they could consume the works to the extent they weren't really consuming them. They're not like people who are spending all day playing the games or selling Sega's games. They are just looking at non-expressive features of the work. How do they run on a Sega console? It's like somebody who takes printed books to analyze the patterns by which the ink spreads out on the page after they're printed. They're not engaging with the expression at all. The humans are not reading. They were reading the work for a purpose other than seeing its authorship. So if you look at the cases, you can find cases like this in which somebody defends the use of a copyrighted work by saying, we don't really care about the authorship. We're making a non-expression related point by using it. It's probably not surprising that these cases come up most heavily in the world of software. Sega versus Accolade was an early example, but a much more modern one would be Google versus Oracle, where Google copies the Java APIs to make a nearly compatible version of its Android software. Oracle, which now owns the Java copyright, sues, claiming that the APIs were creative and copyrightable. But the basic point of Google's defense, which is the Supreme Court in the US validates through fair use, is this copying is not closely related to the protections that copyright offers. Google is doing its copying of the APIs for compatibility reasons, for allowing programmers to reuse their skills, and not for the purposes of appropriating what was original or expressive in how Oracle made the APIs work. Whatever the APIs were, to make things compatible with them, you need to use something like that. You are copying a book, or copying a sculpture, not because it looks nice, but because the sculpture fits exactly into a slot that unlocks it. It's like the crucial moment near the end of National Treasure. Nicolas Cage puts an object into a hole and it turns. The actual carving on the object is irrelevant. It just had to have the right shape to open up the lock. So you get cases like this involving, for example, filing pieces of published scholarship as prior art for patent purposes. Sometimes the owners of the copyrights in those articles object, but the courts uniformly say, no, you had to file this article to show what was known as of that date. No one is reading it for the expressive value of how you described your discoveries. So this turns out to be a perfect principle for large-scale digital users. It's a perfect 10 versus Amazon, the other search engine cases. Putting images in your cache or search engine copying to make an index, that's fair use because you are pointing to where these things are on the web, not because you are actually reaping the expressive value of themselves. AV versus iParadigms. Student sues over a plagiarism checking software, and the plagiarism checking software includes their essays and thousands of others. Well, no one is using this software for the expressive value of the insights the students develop while describing their term paper subject. No, it's using to ask, did you copy from somebody else? Or Google Books corpus scans millions of books under copyright from its partner libraries and builds a massive search engine. People are not using this, for the most part, to read the books in the corpus. They're using it to find out which subjects the books discuss at all. Does this book discuss this topic in the first place? And running through all of these cases, the courts consistently downplay the role of the human in all of this. So in Perfect 10, the court says the users follow a pointer supplied by an electronic reference tool. In iParadigms, the court says the term papers are being used in a way completely unrelated to expressive content. In the Google Books case, the court says that Google Books uses snippets of text to act as pointers, directing users to a broad selection of books. Indeed, Google Books does not supersede or supplant books because, and imagine this in italics and bold, it is not a tool to read books. So all of these cases are driven by the idea that no one is actually reading the books, and therefore the infringement doesn't count. Computers are copying them, computers are analyzing them, but the computers don't count. I think there is a broad principle in US fair use law that non-expressive reading cannot infringe. Bulk automated analyses do not infringe as long as no human is actually looking at the corpus to understand what the things in it say. As long as you're not sharing full books with the public at the end of the story, no infringement. So you see this even in debates about modern AI tools. When GitHub released GitHub Copilot, a tool that auto-completes code based on your suggestions. Type in the header for a function, or type in just a function name, and it will have learned from code uploaded to GitHub common solutions to that problem. So it will spit out a correct set of Eratosthenes for finding primes. It will spit out a correct way to invoke the Twitter API to get the number of tweets from an account. It will write this code for you. Critics asked, doesn't this infringe on copyrights in the code because software is copyrightable? Isn't this use copying from people's code? And the fascinating thing is that the GitHub Copilot people had thought about this. And they said, it doesn't, because we trained it not to return any literal code from any single example unless that same literal code was present in numerous examples. It's not copying any one creator. They have scrubbed their outputs so it emits only widely used common code, which no one would individually claim a copyright in, or it emits new code of its own that is like many people's solutions, but not identical to them. This would be sens affaire in copyright law, things that must be done, common solutions to necessary problems in a genre. And notice how this responds to the objection. It doesn't say it's not fair use to train. It doesn't deal with the training data at all. It merely deals with the outputs, the things that humans are actually going to look at. So the debate takes place in a frame in which what machines do does not count. So at a very abstract level, what has happened again is that the computers, the AIs, have dropped out of the copyright system. They are no longer present there on the authorship side or the readership side. For the most part, the work proceeds as though anything done solely using a computer simply does not touch the copyright system. On the authorship side, we pretend that the people in the system are fully in control. The computers are pure tools. We assign authorship to the people in the system. On the infringement side, we proceed by ignoring what computers do unless there's a human there to see it. If a computer copies a work in the forest and no one is there to see it, it does not make a sound as far as the copyright system is concerned. Okay, so that's authorship and readership. Let me now come to the broader questions of why copyright makes these choices and what it might mean in the future. So I said I'd come back to the arguments that Kerr and Craig make in their great article, The Death of the AI Author. And to simplify a very subtle, very clever piece way too much, their point is that authorship in copyright, as it is in literature, is about the relationship between the reader and the work, and that the author takes a secondary place. So in literary theory, the aesthetic reaction of the work is created by the reader. They experience the work as it exists. The author's intent is secondary. Now, it's true we might reconstruct what the author might have meant, but we're not talking about the actual author at that point. We are imagining who they are, and we are free also to read a work oppositionally or to read it in ways the actual creator did not intend and could not have intended. Different readers experience different things. I think copyright sees that reaction, and that connects to how we think about computers not infringing when they copy. But the reader has this personal reaction upon the copy. Holmes's personality point applies as much to the reader as it does to the author. And so they say, if this is where meanings come from and expressive experiences, what's the role of the author? Well, the author, as we use it in copyright, is something we project onto a work as part of our social relations. The author of a work, I is the author of the articles, Holmes is the author of his opinions, or a sculptor is the author of their creation. All of these things participate because the author is capable of playing certain roles. They have beefs with other creators and they feud. They talk about their breakups in their songs. They expressively participate as people, and we say this is interesting because it comes from what appears to be a person, experiences we can relate to. But they also participate in a legal sense. We have fights about authorship all the time because they affect who can use a work and who can license it. So take the monkey selfie case. Photographer's traveling, leaves his camera out, and the macaque monkey picks it up and snaps a picture of itself. Photographer tries to claim ownership of the resulting work, and other people claim there's no authorship. The Ninth Circuit resolves it on very formalistic grounds by saying, well, a monkey is not an author within the meaning of the Copyright Act as a textual analysis. Photographer has no standing to sue here. End of case. What's this dispute about? The court cannot answer how we aesthetically relate to the photograph or to the monkey. What the court is fighting about is whether he can charge a licensing fee to anyone who wants to reproduce the work. And that is a role that humans can play right now and monkeys cannot. Naruto the monkey can't knowingly give a license to others to use the work, can't manage the copyright and decide to give or grant and refuse others. We have expectations that we need authors to play to work in the system of distributing works to the public. And people and artificial entities can play those roles because they can answer questions about, am I allowed to do this or not? They can manage assets. It's a pretty unexciting, humdrum economic role, but that's the role we need them to play. And right now, there is no way that GPT-3 can play that role in the copyright system. You give it a prompt, it will spit out some creative works, but it can't deal with the boring, mundane mechanics of managing a copyright. Now, it's true you could train it up to do so. You could probably give it inputs are, may I have your permission to do this? And you could ask it to start spitting out licenses. But there will be something missing there. That something missing is going to be our sense that what it's producing is actual agreement to a license and not merely responding to a prompt. So I want to think, what would it take for us to be able to answer those questions differently? What would it take for GPT-3 to truly be treated as an author and to play the social and economic roles that we expect of authors and copyright owners in our system? And philosophically, I have no idea what makes people human. Nobody does. Nobody ever will. I cannot prove beyond the answer to a skeptic's objection. I cannot prove that any of you watching this are conscious or make decisions. Most days, I'm not even sure I can prove that about myself to the skeptic. It's a mystery. So we do the same thing in life that we do in the copyright system. We make pragmatic decisions and we just run with them and say, it's good enough for us. So the Turing test that Alan Turing uses to reformulate the question of whether computers can think, it's behavioral. He asks, can we tell the computer's answers apart from a person's answers? And I note quite tellingly that among the tasks on that test is creation. He asks, can you write me a song on the subject of the fourth bridge? In part because we think that being able to produce creative works is something that we think of interesting and important for humanity. So I treat all of you as conscious, feeling, living beings because we interact and you produce things that express what seems to be inner feelings. You treat me the same way, and it seems to be a pretty good basis for philosophy and for a society. We all participate in those social functions. So what we would need, I think, for machines and AIs to participate in the copyright system in the same way, to be things that could be treated as authors, to be beings that could be treated as infringers, they would need to participate in those social roles. We would need to be living in a situation in which the AI could answer questions in a way that made us attribute to it intentionality and consciousness and purpose and motivations and decisions. And it would need to be capable of being held accountable in a system where it can do things and we need to make it say, we say to it, no, you shouldn't infringe, stop copying that. That, I think, remains a long way off. And it's possible we'll get there. If we do, we'll have reached a point at which autonomous, artificially intelligent agents behave in ways that make us regard them as morally worthy, as creative, as capable of interacting with us on interesting and collaborative terms. I'm not saying that it's possible or likely. I'm not saying that's impossible. But I think that's the baseline that you need to have. In short, if and when we get to the point where we could treat AIs as actual agents in the copyright system, as authors and infringers, we will have gotten to the point when we would treat them as agents, as people, for a lot more than just copyright. We would have made some very, very big strides in how we deal with the artificially intelligent. So I think that there is value in thinking about copyright and AI now. And the value is not in knowing when the AI is the author of the work or the infringer. The answer is it is not, ever. It is not, ever. The value is in helping us understand how copyright applies to the same things it's always applied to. The relations between authors and readers, and how we mediate them to the mutual benefit of both. The short-term value for thinking about AI copyright is how to make a better and more humane and more creative society for authors and readers in the short term. If and in the long run, when AIs enter that conversation as full participants, we'll have these conversations again with different answers, and they'll be part of the community. But for the time being, the machines in the room are helpful because they are tools that help us write, and tools that help us read, and tools that help us understand each other. Thank you, and I would be delighted to have as much of a conversation as time will allow.
So thank you so much for this talk. I myself have a few questions, and I think we have about 10 minutes for questions. So if you'd like to, then please walk here with your avatar onto the enclosed office-like space in the top right corner where my avatar is standing onto the orange megaphones. In the meantime, to begin, I'd like to ask a question. For me, the most interesting or surprising element of this talk was the concept of non-expressive reading, which apparently is something that machines do, that U.S. copyright law has acknowledged, which to me stands in a very stark contrast with, for example, redigi and the line of cases where even operational copying into a cache by a program or a computer is an infringement of copyright, even when for example, in redigi, the whole point of copying was to make sure that no copies exist. So copying as a tool of actually deleting copies. There seems to be something very strange about copying or violations of copyright existing there and not existing when bots scan texts?
This is a great question because it gets at a current incoherence in American copyright infringement doctrine. So VDigi is this case that involves, how should I summarize this quickly?
I can summarize it if that makes things easier.
If you can do this in 2 sentences, you're better than I am at this.
So a company called Redigi wanted to reintroduce secondhand trading for MP3s the way they existed for CDs and vinyl. And they tried to do this by ensuring that when you sell legally bought song MP3 or other copy of a song that you have, it will be automatically and irrevocably erased from your hard drive. So it wouldn't be copying, it would be a bona fide secondhand sale. And the court found this.
Yeah, and they had this was infringing. And the irrevocably part is, I think, the most important one there. I had the CEO of the company speak to my IP class, and he really was insistent on the fact that as they transferred the file to their servers, they deleted it from your hard drive sector by sector. And this was very important to him. Like, it wasn't just that they deleted it once when it was done. They would delete each block of data as they copied it. And the idea seemed to be that there was this thing, this file, that was migrating from your computer to their servers. The file only existed in one place at a time and in only one copy. And they were preserving that, so therefore it was first sale to transfer your copy to their cloud. And the court gives this incredibly formalistic answer that no, there are 2 copies, one copy on your computer, one on their cloud server. They made a new copy and then deleted the old one. And that is different from if you had actually given your hard drive to them, they could have the same copy because it's the same material object. And US law combines this incredibly formalistic analysis of the exclusive rights, that this was violated the exclusive right of distribution and exclusive right of reproduction because a new copy was created and a copy was existed there that didn't before. And then US law has this very broad fair use principle that then undoes so much of that formalism. And I guess my argument is that the cases where that formalism is undone by transformative fair use are the ones that involve non-expressive reading. And so cases like the Google book scanning, where they build a corpus, or the cases like iParadigms, where they build a library of copied term papers, involve non-expressive reading, and therefore it doesn't count. But that they thought VDigi did because it was the same copyrighted work that would then be experienced by other users who bought that copy from you. And so the copying on the way to the end user still counted. It is a very holistic analysis, one that completely disregards the internals of the process and focuses merely on the user experience at the end, but it's laid over a highly formalistic base, which is the exact opposite. And I don't think US copyright law can maintain that distinction indefinitely. At some point, either the formal base or the informal top will eat the other, and we're going to wind up with one set of doctrines instead of 2.
Thank you. I didn't know about these oppositions, or I didn't put them together yet. So does anybody want to come here and ask a question from Professor Grimmelmann?
I think there were some other folks with their hands up, so I'll just encourage again if those folks want to come over to where myself and Professor Szigeti are standing. We'll make sure the questions get asked if we have time. Come on up. And in the meantime, again, thank you so much, Professor Grimmelmann, for your talk. One of the things that keeps sticking with me, and it might just be that I'm obstinate, despite Professor Szigeti's teaching, is like, what do you do when, you sort of spoke a few times about it becoming a hard question. Like, what do you do when so many different people are involved in creating artificial intelligence sort of tools, as you sort of framed them? Do you just find that those are kind of messier and longer court cases when there are so many authors involved in AI creation and maintenance, and so many users sort of using them in these different ways? Like, is it just a kind of a high conflict area now and it's messier, or do you sort of see the case law playing out sort of relatively neatly?
This is very speculative, what I'm about to say. But I'm struck by the same thing that you are, that we have all of these places where there's massively complicated authorship now and relatively little litigation. This shows up in AI. It also shows up in places like open source and in Wikipedia, where you have large numbers of collaborative contributors in projects with very complicated licensing structures, often done informally. And I'm shocked at how little litigation that there's been about this. The same thing maybe in fan art, too, where you have huge communities doing things which range from the amazingly transformative to the minimally transformative. My best guess, now this is the speculative part, is maybe the entire system is going to collapse. That we have a bunch of places in which existing formalisms and doctrines are not well matched to how people consume media. That's one of them. And another one is a streaming revolution in which we just don't get sale of copies anymore as a unit by which people acquire works. It's much less important. Instead, you subscribe to things on a catalog basis, and if you stop paying, you stop getting access. I would not be shocked if a lot of that complexity, like the doctrinal complexity in the VDigi case I was just mentioning, just goes away, and we get copyright replaced by a set of new systems that monetize and restrict certain activities and leave others wide open. And it may be that things we now think of as paradigm infringement cases become non-infringing, and some new things that were previously allowed become restricted, and we renegotiate a different set of boundaries for the whole thing, just because any attempt to enforce the existing ones becomes utterly unworkable.
Thank you. We could talk more about that, but I'll let others jump in.
So Vijay, if you have a question, feel free to ask.
Yeah, I do. I do have a question. So thanks, James, for this great conversation. I really enjoyed it. So my question, so I'm not a practitioner of law, but I do have interest in terms of data advancing artificial intelligence more from an application side. One thing that I'm struggling to understand is, because when I look at AI, I find that very similar to the camera that I have. So say, for example, if I go to the Statue of Liberty and I take a photograph, the camera is responsible for capturing the photograph. So the aperture, the lighting, everything around is what makes myself the author of that photograph. And when I use AI for generating content, which is similar to literature, I do believe that AI is the tool that's helping the author, the person who is using it, to do the same thing that the camera does. So the camera does not claim authorship, whether it's clicked by a monkey, a human, or any of those. Similarly, if it's a monkey that generates an algorithm, even the monkey does not claim authorship. So what I'm trying to understand is, how do we make that machine-machine distinction and a machine-human distinction? Because machines by themselves are not arguing for ownership or copyright, whereas it's the humans who are using the machines that are more concerned about the authorship. And if I were to take that a step back in terms of why this authorship is becoming a problem, that's more around the incentive that you have to have creative work, the ability to monetize it, the royalty that's behind it. So there's a big incentive in terms of the economics behind it, which is what is leading to all these discussions. And if we were to consumerize technology like through AI, everyone can be an author maybe in a future world. So I'm trying to understand how that all these plays around in terms of the copyright law, the authorship, and all those kind of things.
So it's a great question. I love your point that nobody even thought that the camera in the monkey case should be the author. It wasn't even raised. Like, I'm going to put that when I teach copyright from now on. That's just great. It makes me think. I think the answer is it's pragmatic. We litigate these questions when somebody shows up to claim I have a copyright interest and therefore you should X, Y, or Z. And the AIs don't show up in court to demand anything. So from that's why they get ignored on the days when they show up in the future, when they can show up in court and make convincing arguments and have lawyers, and then we'll listen to them. And that's a point that I don't see it happening soon, but philosophically, science fictionally possible. The other thing is it's totally pragmatic in what we see as authorship. So your camera example is great too, because traditional camera, you control the aperture and the exposure, like you say. If I use this thing, yes, I point at the thing and I tap, the shoot button. It does a lot more than just open a sensor and record light. It has complicated denoising algorithms in there. It might take several photos and combine them computationally in order to select something that has both the foreground and the background in focus. The cameras we are using now invisibly do so much work that we don't even notice. But that's because we have a social convention of what a photograph is and how it came into existence. And if I say, I took a selfie, we don't have to talk about all the details. The concept of selfie, as I use it and you use it, captures the idea that I pointed and got the right framing, and none of the rest of us have to worry about the details. As long as we can get away with ignoring the details of what's happening, we don't have to answer these questions. And social agreement does a lot of work in ignoring details.
Yeah, thanks, James, for that perspective, because I think again it goes back to the fact that it's all about social agreement, removing conflict, which is where the legal aspects come in. So I really appreciate those insights.
Yeah, domain sense law is a system for helping us successfully get along, and it does that very often by just deferring to what we all already agree on, whether what we agree on makes sense or not.
So, in the interests of not being too late with the program not slipping up too much, I think that I do have to call this talk to a close. Next presenter will come to present in 2 minutes, but I would like to very much thank Professor Grimmelmann for joining us. I certainly enjoyed this talk very much, and I hope that I can keep in touch. And I'm looking forward to the next talk.
Thank you very much for having me here. It's been a delight. And anyone who wants to get in touch, please do. One of the advantages of my unusual name is that it's easy to Google.
Lovely. Thank you both so much. And I will, again, we've sort of run over into the break, so I hope that folks have turned off their camera and gone to make coffee during the discussion. We will start up our 10:30 sessions on time, so you can find in the program the rooms listed there. Rooms A, B, and C all have awesome talks. I wish I could be at them all. And I want to give a shout out to Hannah and Catherine, our volunteers who are dedicating their time to help you find your way today. So please do, if you're stuck, you can look them up and ask for assistance. And we'll see you all. We'll see you all momentarily in the next round of awesome, as it were. And thanks again, James, so much for helping us kick off the day.